let's understand and decode this verdict, its ramifications, and does it really open Pandora's box with three legals. Vikas Singh is former Additional Solicitor General of India. Aryama Sundaram is senior advocate. We also have Faizan Mustafa, former Vice Chancellor of NALSAR University of Law. Thank you so much for your time. Vikas Singh, let me get straight into the verdict. And it is being seen as a victory for the Hindu side, for those 5 women petitioners, and a setback for the Muslim petitioners. What made the Muslim argument weak?
So, Maria, I don't know what has been argued, and to be frank, I have not seen the order also, which has been passed today. I've only read it from the from the news feeds that have come so far. But there are apparently trying to make a distinction between turning a place into changing the character of a place and vis-a-vis the right to worship in a particular place. Now, according to me, these are completely intertwined, and these can't be separated. Until the challenge to the Places of Worship Act, which is pending in Supreme Court, till some interim order is not passed in that matter, or till such time the act is not set aside, if you ask me, I don't see how this suit should be continuing and any adjudication being happening in this matter. So unless I see the actual judgment, I really can't comment. But that is my prima facie view, that this order has gone trying to make a distinction between conversion of a religious place to a right to. So it will be very just imagine somebody wanting to come and offer nawaz in a temple. It's something which is not done. So similarly, you can't say that I want to offer prayers in a mosque without it being converted into a temple. So really speaking, it is begging the real issue, and somebody will have to grapple with that issue at some stage. And according to me, it should have been now only.
Okay. Aryama Sundaram, this exact point that is being made by Vikas Singh, petitioners have prayed for the right to worship, they got that. However, can this question really be sorted out or settled without determining the religious character of this place?
The point and issue is this. We are on the question of maintainability of the suit. That is, whether such a suit can be filed at all, assuming everything was right. There is certainly a bar to reopening questions of title, questions of when a place of worship has been in existence for a number of years, as the statute is. But this is not a suit for type. It's a suit for right to worship. And it appears to be a suit based on both custom and what I would call a civil right, not an ecclesiastical right necessarily, but definitely a civil right.
Okay.
So, as to whether this right is made out finally, as to whether all this can be proved in a court, is a matter to go for trial. The aim today was to see whether this suit should go for trial at all or is barred by some law. On the face of it, when the declaration is not with regard to either altering a place of worship and saying it can no longer be a place for the worship of a given community, given religion, denomination, but should be for somebody else. If that is not so, then it's not changing a place of worship. To ask for yourself having a right to worship there may not amount to a change of a place of worship. Equally, it is not a claim on a property right by which the right to the mosque is being claimed. Yes. And therefore, on the face of it, on the bare allegations in the plaint, it cannot be that the suit is barred by any law, which appears to be what the district court said. Of course, this will be subject to various appeals which will be filed, I'm sure. But offhand, to comment on this judgment, would really say that the judgment has really only given these plaintiffs a right to proceed and say, all right, prove your case that your civil right or your right to worship has been in some manner been prevented. And we'll have to, in the trial, ensure that the trial does not get broadened into a question of seeing whether the place of the worship in the very mosque should be changed, or the religious denomination who can worship ought to be somebody else, or the mosque should be turned into a temple. If those are not the questions. And the court should also see that those issues don't go into it. But it's restricted to what the plaintiffs are claiming, which is they say we have a right to worship, not that the mosque should not be there. But that seems to be the prayer, and that seems to be what has appealed to the district court to say that it is maintainable and let it go ahead for trial. As to whether they would get the relief, whether they can establish this, as to whether they can show that what they are really asking for is not going to trample on the religious rights of others, will be a matter for trial and final decision.
Yes. So that is certainly the nature of petition, as you were pointing out rightly, Aryama Sundaram, but you heard from Vishnu Jain. He seems to indicate that there are multiple petitions, and one petition is also about title of this entire site, which is Gyanvapi Mosque. Professor Faizan Mustafa, based on the evidence that is there already, can this place be converted into a temple until Places of Worship Act 1991 is there?
The whole question is, Maria, that the judge in Varanasi court today very clearly in his 26-page order says that these 5 women petitioners are not seeking conversion of place from from mosque to the temple. They are not making any ownership claim either. What he is saying that the petitioners merely want to worship. They have asserted that they were worshipping till 1993 and thereafter they have been stopped.
Yes.
And therefore the judge concludes that the 1991 Act prohibits conversion.
Yes.
But there is no relief of conversion sought in this petition. And that's why the 1991 Act does not apply. Similarly, he is saying that the 1991 Act would not apply in this case because there is a Kashi Vishwanath Temple Act of 1983.
It's very, very technical.
Passed by the UP Legislative Assembly, which defines a temple. And the argument of the petitioners is that this property within the meaning of Kashi Vishwanath Temple Act was declared as a property, as a temple. And if it was a temple in 1983, therefore the question of 1991 Act being applicable in this case simply does not arise. So I think the problem is far more complicated than it was commonly understood. As you go to the judgment, they say that even the property has not been registered properly as waqf, and of course they say that Aurangzeb did not create a waqf, and the mere entry of a property as waqf in the revenue documents does not make it a waqf property. Now these are all very, very important observations, highly technical and legal. I think it is a major setback to the Masjid Intizamiya, committee.